Well, I was on the 25th of January of 2020 when I was last here. I had the opportunity to speak to you all about the Confederate Act of Sequestration. Since then, my research has continued. It's developed nicely. The manuscript is finally starting to develop, and things were going along just perfectly until somebody started asking me questions about the act of sequestration, and they started asking, "Well, was this just a domestic policy? Did it have an international dimension to it?" And that really kind of piqued my interest, and so I started looking into this, and lo and behold, I end up with another chapter to write for my book. So that is in part what I'm here to talk to you about today. I want to begin by just kind of recapping some of what I have already discussed with you all 4 years ago. And for those of you who weren't here 4 years ago, you have no idea what the act of sequestration was, this will be useful to you. I want to talk a little bit about this. I'm going to introduce some new things that I've discovered. And I'm going to transition into how this very quickly developed into a diplomatic strategy in dealing with Great Britain. So that said, during the Civil War, Confederate District Court judges, receivers, grand juries, they presided over a campaign of confiscation and intimidation. Now, they were armed with the Confederate Act of Sequestration. And the goal ultimately was to enforce loyalty and to squelch dissent. Well, by the end of the war, millions of dollars of debts owed to Northern creditors, and along with millions of acres of land and untold amounts of personal property had been confiscated, sold at auction. Untold numbers of ordinary folk, they had been stripped of their property. Some have been threatened, some have been fined, some were imprisoned, or worse. So it was the 1861 Act of Sequestration that empowered Southern District Courts to engage in acts of legal turpitude perpetrated against their fellow Southerners. Tyranny and corruption abounded on the home front, as court officials often enriched themselves with the property that they had seized from people being accused of being disloyal to the Confederate cause. We talk about the effects of morale on the home front. You can well imagine the effect that must have had. Acting with impunity, court officials menaced the home fronts relentlessly, seizing and selling property. But a close examination of the day-to-day application of this law reveals that it was specifically designed to intimidate and control ordinary folk. Its nefariousness was hidden behind a veil of judicial secrecy that was unseen by the public eye. It was characterized by a widespread disregard for civil liberties, personal property rights, and a vicious realpolitik. Perhaps most significantly, the sequestration pulls the curtain back on the depth and the strength of home front loyalty, revealing a rapacious court bureaucracy and a Confederate government that was deeply suspicious of its own. So where does this all begin? Well, it began actually on do I need to get a low battery? It began on the 6th of August. It was on the 6th of August that the United States Congress approved the first Confiscation Act, which laid the legal groundwork for federal forces to confiscate Southerners' private property that was being used to aid the rebellion. Well, now, it wasn't specifically mentioned in the first Confiscation Act, but it was understood. Then later it was confirmed by executive order that property included slaves. Right. So that being the case, the government in Richmond was compelled to act. And so on the 30th of August, 1861, just a few weeks later, the Confederate Congress passed the Confederate Act of Sequestration. The Act of Sequestration did a lot of things, but I'm going to really whittle this down to some very specific things. First off, it's charged district courts charged district courts with implementing this law. So the judges in the various Confederate states, they would preside over the implementation of the act of sequestration. But it also created two specific groups to help facilitate the execution of this law. First off, it created a group of receivers. Receivers were lawyers who were appointed by judges to implement the law within their certain districts. Okay, so they were responsible for ferreting out liable property and debts, and then prosecuting people who were found guilty of violating this law. They were aided in this endeavor by federal grand juries. Now, federal grand juries were impaneled in every receiver district. They could number as many as 30 men. And so they worked together to implement this law. And that's where you see, that's where the rubber meets the road with the application of the act of sequestration. It also defined who the target was, alien enemies. And so the definition that the act of sequestration gave for identifying an alien enemy was anyone whose domicile was outside of the Confederacy. I want you guys to make a good mental note of that, because as you're going to see in just a moment, the overwhelming majority of people who are accused and convicted of being alien enemies live in the Confederacy. Okay? Well, who was the chief author of the act of sequestration? It's very important to note that the main author was none other than Judah P. Benjamin, who was the very first Attorney General of the Confederacy. He will not remain the Attorney General for long. All right. Benjamin was a very clever lawyer. He was considered to be the real brains of the Davis administration. And so he was heavily involved in crafting all of the specifics of this law. Well, I'm going to read to you just a little bit of some of the specifics associated with the law, so that you have some idea of what was going on here. Now, ostensibly, the Confederate Congress intended sequestration to strike a blow at Northern financial interests within the Confederacy itself. It called for duly appointed court officials, or be receivers in federal grand juries, to locate, now I'm quoting from the act here, all and every lands, tenements, hereditaments, goods and chattels, rights and credits within these Confederate states, and every right and interest therein held, owned, possessed, or enjoyed by or for any alien enemy. So basically, anything that had any value whatsoever was liable to be confiscated. All right? Such property would be sequestered by the Confederate States of America and in turn sold, with the proceeds paid into a fund administered by the Treasury Department. A board of 3 sequestration officials would hear indemnity claims made by loyal Confederates whose personal property had fallen prey to confiscation by the Union. So in theory, you could apply for an indemnity if you had lost property as a result of the advance of federal armies into Confederate territory. All right. I've been researching this topic for almost 17 years now, and I have yet to find anyone who ever received an indemnity. You know, I probably goes without mentioning, but I'll mention it nevertheless. Southerners bore the brunt of wartime confiscation. I mean, just like federal confiscation, sequestration would be enforced on the Confederate home fronts. And so the difficulty in enforcing the act of sequestration is going to really lie in locating liable property. So in order to do that, Confederate officials simply dismissed concerns about privacy or the sanctity of attorney-client privilege, and they chose to target business and tax and legal records. And they figured that those would be useful tools at locating, all this potential property that they could confiscate. But the bulk of information about where to find liable property came from people on the home front. And to quote historian Brian Dirk, let's read his quote here. Sequestration required every Southerner to turn informant for the government. Simply put, the authors of sequestration intended to squeeze the home for information, and that is precisely what they did. Well, excuse me. Read to you a little bit here about what the act specifically said about this process. The act specifically stated, it is the duty of each and every citizen of these Confederate states speedily to give information to the officers charged with execution of this law. Indeed, should anyone prove reluctance to provide the government the information that they required, sequestration officials were granted extraordinary punitive authority. They could have you in prisons simply on accusation, and many people were. Well, so operating almost like a secret police force, both receivers and grand jurymen randomly interrogated individuals and diligently kept a probing eye and suspicious eye on people within their districts. When I say that, what comes to mind is the image of the Lord of the Rings movies, the ones with the two towers with that all-seeing eye that just kind of looks everywhere. That's kind of the image that I get, at least when I think about this. And to give you some idea of just how aggressively they would do this, I have a quote here from a receiver, Archimedes Davis from Virginia. Are you not agent for a man named Alexander, an alien enemy who has interest in the lands known as the Campbell Survey? Davis wrote to William Nash of Abingdon, Virginia. Tell all you know in regard to that or any other lands owned by alien enemies. They were threatening, they were menacing, and they would receive this information by interrogating your neighbor. So they would force people to give information to the government. In fact, to ensure success at locating alien assets, the Sequestration Act required, and the district courts demanded, that all residents be immediately forthcoming in reporting all alien assets in their possession and in the possession of a neighbor. I don't think you need to think long about that to realize the kind of corruption that would generate. If you were covetous of your neighbor's property, it's convenient simply to say, well, he's an alien enemy. And that happens time and time again. Well, most significantly, and by the way, you would receive, if you were suspected of being in possession of alien enemy property, you would receive a bill of interrogatories, which was a list of 5 invasive probing questions that required a very precise answers. But most significantly, if you were a recipient of a bill of interrogatories, and if you were one of the hundreds and hundreds of thousands of people for whom garnishment proceedings were launched, you were automatically considered disloyal by Confederate officials because you had not been immediately forthcoming with this information. You were trying to hide something. So, again, with the bill of interrogatories, it contained 5 very probing, invasive questions. Most people who received the bill of interrogatories found it necessary to hire an attorney to help them craft their written response. This certainly was the case for 2 women in particular, Mary Barnhart and Adeline White. Both women were of Cabarrus County, North Carolina. Both women were illiterate, they were elderly, and they were living on land that was left to them by deceased husbands. Ironically, both women had sons, but both of their sons were said to be living in California. So their domicile is outside of the Confederacy. Well, based on that, Asa Biggs, the judge of North Carolina, declared, without bothering to verify the location of these 2 young men, Asa Biggs declared these 2 young men to be alien enemies. He ordered their respective lands to be sequestered and sold. Both Mary and Adeline were booted off their land. They were left destitute and dependent upon the goodwill of friends and family for their maintenance. This was not uncommon. Women on the home fronts were easy targets for some court officials. And sequestration judges, they applied the law with really cold indifference to circumstance. Those with no political connections or legal recourse were at the greatest risk of losing property to sequestration officials, whether they were associated with alien enemies or not. I'll give you a good example of what I'm talking about here. In 1863, Margaret Wallach of Culpeper, Virginia, she was living at her childhood home, but her father, William Wallach, had been jailed in Washington, D.C. since the very beginning of the war. Well, receiving that information, once again, receiver Francis L. Smith petitioned Judge Halliburton to sequester the imprisoned Wallach's real and personal estate because his domicile was outside of the Confederacy. Never mind that it was a jail cell. Well, Halliburton agreed and ordered Margaret Wallach evicted from the property. Soon after, Wallach's entire estate was sold at auction. And this is not uncommon. It's not uncommon at all. Well, in South Carolina, the corruption was, I think, even more eye-popping. In September of 1861, a district attorney in Charleston indicted British merchant Walter Huey and charged him with being an alien enemy. Judge Andrew McGrath, the judge of South Carolina, ordered all of Huey's possessions, and I'm quoting from his order here, sequestered and delivered the same into the custody of John W. Caldwell, receiver, and that said receiver do hold the same subject to further order of the bench. Well, meanwhile, Huey, who was living in Charleston, right, but yet accused of being an alien enemy, he mounted a vigorous defense. His first action was to contact Robert Bunch, who was the British consul in Charleston. Bunch was very familiar with Huey. He knew that Huey was a strong supporter of the institution of slavery and a very pro-Confederates. He refused to help. So Huey's next move was to contact none other than Charles Priolo, who was then living in Liverpool. Priolo, we're going to talk about Priolo in just a moment here, but he was a very prominent businessman from Charleston and had a lot of influence throughout the entire Confederacy. He sent messages to McGrath assuring him that Huey was a good guy, and so based on that, McGrath he stopped harassing Huey, and 1 month afterwards, he ordered that all of Huey's possessions be returned to him. But much to McGrath's surprise, the possessions that belonged to Huey were never handed over to the receiver Caldwell. They were, in fact, left in the possession of the bailiff, James McGuire, right? And again, further to McGrath's shock and dismay, it was later discovered that McGuire sold all of Huey's possessions and scored a tidy profit for himself. Well, McGrath didn't like this one little bit, and he ordered that McGuire appear before the bench to give good reason why his position should not be vacated. In many instances, district courts allowed sequestration to be used to facilitate covetousness in certain communities. And to give you a really good example of this, in November of 1861 in Galveston, Texas, the grand jury there took the deposition of John H. Crossman, who alleged that British merchants and trader we're not advancing.
We did move on, I thought, didn't we? We had moved on. Okay. Have to come out. Okay.
Well, as I was saying, it was in November of 1861 that the grand jury in Galveston, Texas, took the deposition of John H. Crossman, who alleged that British merchant and trader James Hawley was an alien enemy. That he and also mentioned that Hawley owned a dredge boat that was docked in Galveston. He claimed that 2 years prior to this, he'd overheard Hawley utter seditionary statements. Well, based on Crossman's testimony alone, Hawley was arrested and imprisoned as an alien enemy. All of his property was confiscated and sold at auction. And guess who bought all of his property? John H. Crossman, his accuser. This too was about as common as could be. In fact, that was the norm, that when people accused someone of being an alien enemy, they usually bought the property that belonged to the alien enemy, and usually at rock bottom prices. That certainly was the case for Crossman. Well, it was these two cases right here, Walter Huey and James Hawley, that really piqued my interest. I was really interested in knowing why would Confederate officials, officials of the act of sequestration, why would they be so concerned about going after British merchants? I mean, they're unoffensive. They're simply foreign nationals living in the Confederacy. What's the connection? And so I started looking into this, and this is right about the time that people started asking me questions about was there an international dimension to sequestration, and that's when things started to unfold. What I discovered was that from the very beginning, Confederate leaders understood that victory over the United States would be contingent to a very large extent on British recognition and support. And at the very beginning of the Civil War, Confederate leaders had good reason to be optimistic that Britain would, in fact, intervene on their behalf. On the eve of the Civil War, the textile industry was Britain's single largest industry. And Southern cotton planters provided Britain with more than 80% of its raw cotton. So simply put, the burgeoning British textile industry and the Confederate States of America, well, they were inextricably linked. But there was a little bit of a problem though. Britain was, I'm sure you all already know this, but Britain was reluctant to insert itself into this conflict. It was the policy of Her Majesty's government to remain neutral. In fact, the Parliament had already passed the Neutrality Act, which made it clear that Britain's position would be neutral in this conflict. But there was division within Parliament, and initially, my understanding was that the division was along party lines, that conservatives were in favor of supporting the Confederacy and that liberals were opposed to it. Well, as I have since discovered, this is not necessarily the case. Mike and I were talking about this just yesterday. There were lots and lots of liberals who were very much in favor of supporting the Confederacy for a variety of reasons. And arguably, the most famous of them was that guy, the Prime Minister, Lord Palmerston. Well, frustrated with Parliament's reluctance to get involved, to help the Confederacy out, the Davis administration designed a two-pronged diplomatic strategy right at the very outset of the war to kind of encourage Parliament to get involved. First off, they would rely heavily on the influence of Charles Prideaux. Show you an image of Prideaux there. That's Prideaux. For what it's worth, Prideaux was from a prominent Charleston family. He's the head of the firm Fraser and Trenholm and Company, which is a shipping company. They had offices in Charleston, in New York, and in Liverpool. At the very beginning of the war, Prideaux moves to Liverpool. He moves the headquarters of his company to Liverpool, and it was from there that he would help the Confederacy acquire war material that it needed, and essentially offered the Confederacy an unlimited line of credits. So Prideaux plays a big role in the story, especially with regard to diplomatic strategy. So they were going to rely heavily on his financial influence and on his political influence. In fact, they were certain that Prideaux would be able to convince conservative members of Parliament to float a bill that would recognize the legitimacy of the Confederacy. The second prong of their strategy was to basically to withhold cotton from Britain. the Davis administration, they ordered the burning of thousands of bales of cotton that were meant to be sent over to Britain, to British textile mills. This was an aggressive and a very deliberate, calculated move on the part of Richmond. They're trying to create an economic crisis in Britain that ultimately would force Parliament's hand. Well, this strategy worked at first, at least for a short while. The absence of Southern cotton in Britain, the sudden absence, I should say, led to a bit of a crisis, particularly in Lancashire and in Manchester. But as it turns out, there was a modest surplus of cotton in Britain at the time, and that kind of took the edge off of this crisis. More's the point. The British cotton supplies were heavily supplied by the success of blockade runners as the war progressed. Even at the high water mark of the blockade there on the Confederate coast, more than 80% of blockade runners were successful again. And so Britain really doesn't suffer this sudden loss of cotton for very long. All right. Well, frustrated that this strategy didn't work, the Davis administration adopted a new strategy. They took a new tack, and that is where we come back to our friend Judah P. Benjamin, who by this point is now the first Secretary of State for the States of America. So he's the author of Sequestration, is now the architect of Confederate diplomatic strategy. And so that's really kind of piqued my interest. I thought that was really, really interesting. And so I looked into this a little bit more. And what I discovered was that the new strategy that Richmond developed was, first off, they were going to demonstrate their legitimacy on the battlefield. Right? They were going to win a major battle on Union territory. And if they did, certainly that would cause Parliament to recognize and support the Confederacy. So that would ultimately lead to the Maryland campaign, which culminates in the Battle of Antietam in September of 1862. While all of the preparations for that campaign were being made, what I discovered was that the Confederate District Court records, and this is particularly true for South Carolina, Georgia, and Texas, 3 of the 4 states where you saw the most successful blockade run, right? In those 3 states, there is a sharp, dramatic increase in the confiscation of property that belonged to British merchants and traders, specifically. And I thought that was really, really interesting. So sharp was the increase in Georgia, in fact, that the British consul in Savannah, Edmund Molyneux, and I'm sorry I don't have an image of it, couldn't find one at all on the internet, but he wrote a letter, a rather emotional letter to Judah P. Benjamin, decrying this move, this seizure of all this British goods and materials he decried it as a strong-arm diplomatic tactic. Well, once again, we come back to Judah P. Benjamin. And I thought that was really interesting because Benjamin seems to have inserted into this whole story at several different points. So I went to Manhattan and I spent a week at the Center for Jewish History, going through the personal diary of Judah P. Benjamin. And what I discovered after hours of endless reading were 2 entries in his diary that seems to seal the deal. The first one came on the 12th of December, 1861. The dates are important. 12th of December, 1861. This is after the initial Confederate diplomatic strategy was proven to be a failure. Mr. Davis is in favor of my suggestion. Sequestration will be employed. Palmerston will have no choice. That seemed to really put some punctuation on it. It was Judah P. Benjamin, the author of Sequestration, who is now using that same piece of legislation as part of diplomatic strategy. The second diary entry came on the 27th of November, 1863. Sequestration of British cotton has not had the desired effect. Well, so it was Benjamin, who again was the author of Sequestration and was also the architect of Confederate's diplomatic strategy. So this is how this purely domestic policy becomes an international diplomatic strategy. I want to give you guys some idea of just how sordid some of this story really is. And this story has to do with the British consul in Savannah, Edmund Molyneux. Molyneux, if you're not familiar with Molyneux, he's a real piece of work. He had been he was the consul in Savannah from 1831 to 1863. So obviously he had lived in Georgia for quite some time. He married the widow of a wealthy plantation owner. He owned many slaves. He was a wealthy man. He dealt in cotton. In his capacity as a consul there in Savannah, it's kind of interesting. He was not a consul general. He was simply a consul. And that being the case, he was allowed to engage in commerce. He could trade, do business there in the United States. It's not clear whether it's not clear if he was not paid as a consul or if he wasn't paid very much. Whatever the case may be, he didn't make a lot of money as being a consul there in Savannah. He was implicated in one incident by his countryman, Robert Bunch, the consul there in Charleston. Molyneux was implicated in an infamous incident that took place on Jekyll Island. A sloop in 1859 pulls up to Jekyll Island with about 40 African slaves. And they're offloaded there on Jekyll Island. They're sold and distributed throughout the state of Georgia. Molyneux was associated with that. So he's trying to revive the slave trade, the Atlantic slave trade, in doing that, which of course was directly against royal policy. Well, as I was researching all of this at the Georgia Historical Society and at the National Archives campus in Atlanta, I came across some rather interesting entries in the Confederate District Court records. The first entry came on the 27th of February, 1862. A man called Stanley Stevenson appeared before a justice of the peace to swear that he is British and demanded the return of his personal property. He was living in Monroe County, Georgia. Pull up a map here of the state of Georgia. So Monroe County is right about here. It's just north of Macon. Okay, the property that was listed in this entry included 200 bales of cotton. Okay, the second entry that I came across came on the 13th of July, 1862. Benjamin Edwards of Columbus, Georgia, Columbus is way over here, appeared before John Stoddard, again a justice of the peace there in Muskogee County, to swear that he is British and that the seizure of his property by Confederate officials was a breach of the law. Once again, in the inventory of the property that was seized, 100 bales of cotton. The third entry that I came across was on the 11th of August, 1862. Charlie Clifford of Bibb County. Bibb County is where Macon is located. Charlie Clifford appeared before the justice of the peace to swear that he is British, wanted his property in return. Once again, the inventory of his property, 300 bales. What do these men have in Edmund? They're all British. They're all merchant traders. They are all acquiring bales of cotton that they are going to send to Molyneux in Savannah. And I want to point a couple of things out to you. You see this highway right here. This is Interstate 16 that goes from Macon to Savannah. Well, that highway follows almost exactly the routes of the very first railroad ever constructed in Georgia, the Georgia Central Railroad and Banking Company. Well, during the Civil War, the president of the Georgia Central Railroad was a man called Richard Cuyler. He doesn't like Molyneux at all. The two men don't get along at all. The other thing I want to point out to you is that just before the war got started, the price of cotton, price of Southern cotton, was 50 cents a pound. Now, the average bale of cotton in the 19th century was about 400 pounds. Today, it's kind of standardized at 500. But on average, it was about 400 pounds in the 19th century at 50 cents a pound. Well, once the war got started, the price of cotton tripled, went up to $1.50 a pound. Molyneux was, through his contacts, these British traders and merchants in the state of Georgia, Molyneux was acquiring bales of cotton at 50 cents a pound, pre-war rates. And his goal was to have all that cotton shipped to Savannah, where he would then send it on to Britain and sell it at $1.50 a pound. Okay, so all of this cotton was going to be sent to Macon, where it would be loaded onto trains owned by the Georgia Central Railroad. It would be sent to Savannah, and then from there sent on to Britain. Richard Cuyler, the president of the railroad, of course, is aware. He knows that this is happening. Bales of cotton are being sent to Savannah. Once the bales of cotton arrive in Savannah, Richard Cuyler informs the district court judge in Savannah of the arrival of this cotton and that it belongs to Edmund Molyneux. The judge threatens Molyneux with prosecution as an alien enemy. He confiscates the cotton and it's sold at auction. It's sold at 50 cents a pound. Guess who bought the cotton? Richard Cuyler, who then turned around and offered to sell it right back to Edmund Molyneux for $1.50 a pound. So that is precisely why Richard Molyneux leaves Savannah in 1863 in a big huff, because he's just lost a fortune. I mean, you look at the numbers on this. You're looking at my goodness. Well, let's see. It'd be $600 a bale. But you multiply that, there were 800 bales of cotton that were shipped here. I mean, you do the math. It's an astronomical amount of money that he stood to gain by selling this cotton, and it was all ripped away in this interesting double cross that's going on. This kind of sordid financial behavior was absolutely common throughout the Confederacy. I would assume it's probably true throughout the North as well. But much of this is associated with the act of sequestration. And I think that is really, really fascinating. It's a story that I'm looking to tell in my forthcoming about this topic. Thank you.